Good evening, everyone, and I wish everyone a wonderful day. I want to welcome you to the Southern California uh, second installment in partnership with the Church State Council of the Pacific Union to our webinar. We are endeavoring to have a webinar every other month at the end of the month, and this is our second installment. We thank you for joining us and being with us today. Our theme for today will be Liberty and Justice Considered, Workers' Rights. And so we're happy that you are here. And before we get started and we bring on Elder Alan Reinach, I'm going to have a word of prayer. So let's pray. Father, we're just grateful for this Sabbath day. We're grateful for all the blessings that you bring to us. And as we go into our discussion today, we pray for the outpouring of your Holy Spirit to be with us, to guide and to direct us in all that we do. So bless us and be with us, we pray, in Jesus' name. Amen. At this time, I'd like to invite Alan Reinach to come and to take over.
It's good to partner with you. And, we've come up with this title, Liberty and Justice Considered, and I'm sure we're going to be doing a number of installments over the course of time and considering a lot of different issues. So by all means, if there's some issues that you want us to address, let us know. I believe that everyone has access to a chat function wherever you're watching, and we will be able to see those comments and questions, and that's how we're going to be able to include, and we will, at different points throughout the program, include your comments and questions. But I want to start with a brief introduction. Your work is important to God. Our attitude, the quality of our work, bears witness to the influence of Christ in our lives. In Isaiah 58, the prophet does a takedown on conventional religion. God rejects even the most diligent followers of religious ritual who, in the day of their fast, oppress their workers. And the book of James in the New Testament takes up the same theme of judgment on those who oppress workers, where the wealthy are called to account because of their cruelty to workers, and especially not paying them their wages. The Church State Council, which is the religious liberty ministry of the Adventist Church here in the Pacific Union, we have long worked to advance the rights of workers. But when I first came to the Pacific Union nearly 30 years ago, our workers' rights emphasis was primarily the legal services we provide to persons of faith who suffer religious discrimination in the workplace. And we're going to do a segment about that before we conclude today. But 16 years ago, I attended for the first time the annual conference of the California Employment Lawyers Association, aka CELA. I joined the newly formed legislative committee, and through the years, we've worked for major changes and had some wonderful successes in changing laws that protect workers. And today, as our guests, I'm very pleased to invite two of my colleagues from our CELA Legislative Committee. Scott Bernstein is going to be with us, but only in the pre-recorded sessions. He had prior plans today, but was eager to join us. Scott has served as co-chair of CELA's Legislative Committee for as long as I can remember. He frequently testifies before committee hearings, both here in California and in Congress, on behalf of workers' rights. Beth Mora is with us live today. Beth is an attorney with a private employment law practice and also serves on our legislative committee and also does some supervisory work for Legal Aid at Work, which provides legal services to low-wage workers who are victims of wage theft or have other rights that need to be protected. So we're going to start with 3 pre-recorded sessions that we did with Scott and Beth earlier this week. And after each one, there will be time for Beth and I to address whatever comments or questions you put into the chat. At least we'll try to take some of them. Now, one of the takeaways that I really hope you get from this webinar is that your voice really does matter. You can help us protect the rights of all workers. And After we do the segment on workers' rights, the 3 pre-recorded sessions, and your comments and questions, I've asked Beth to address a subject of her particular expertise, which is anti-Semitism. So she'll do a segment on that, and I'll wrap up the program with a little primer on dealing with Sabbath accommodation problems in the workplace. Well, just a few more comments before we get to our first pre-recorded session. Some observations about where we are in the labor market today, because it's in considerable upheaval. Due to the pandemic, a record number of people are unemployed, but there are also a record number of job openings, and record numbers of people are quitting their jobs. And at the same time, companies are having difficulty recruiting. It seems the old rules of underpaying and either under or overworking employees seems to be out the window, and there are new rules. One of the speakers in a podcast I heard recently discussing these issues characterized this as the, quote, "take this job and shove it" economy. Workers are refusing to return to dead-end jobs that pay too little and offer less than full-time hours and no benefits. They're seeking more meaningful work and work that can actually support their families. Another podcast I heard projected dramatic changes that artificial intelligence will produce in the American workplace in the next decade. Beth and I were talking about maybe briefing you on some of those issues of AI, but she thought people's eyes would glaze over. So I'm going to assume that Beth is right. We won't be talking about AI, but you're still going to want to pay attention to it. Well, whether these predictions come true or not about the changing American workplace, the question is it changing for better or worse? And at the core of these changes is this question: will American companies treat workers as human beings or as mere cogs in the machine? Or, as the lyrics of an old Pink Floyd song go, just another brick in the wall? And accompanying this question is this one: will you support our efforts to ensure workers are treated with dignity and respect? With that question, let's go to our first pre-recorded session. We want to talk about laws that have really made a difference for workers in recent years. And I'm going to start with you, Beth. Talk about a law or a set of laws that's really made an enormous impact for working Americans.
Okay, thank you. That is a very good question. I'll start first with sexual harassment. It was already in existence in 1991, but I don't think that we actually understood it or appreciated its value. So I'm going to start with Professor Anita Hill and now Supreme Court Justice Clarence Thomas, the October 11th, 1991 hearings, and take us all the way to 27 years later, post Me Too, Dr. Blasey Ford and her hearings with now Supreme Court Justice Brett Kavanaugh. There weren't many dramatic differences between those two hearings, but we learned a lot about sexual harassment, about what our society was willing to accept and what was happening in society with the understandings of sexual harassment. The other major shifts in law and changes in the law came with gender discrimination. And that really came to light with the passing of the late, great Justice Ruth Bader Ginsburg. She made amazing shifts in the law with casework she did as a practicing attorney, then as a justice at the U.S. Supreme Court with her.
I'm sure.
It was definitely with her dissenting opinions, very often referred to as the notorious RBG, and her impact on gender discrimination and gender discrimination law and equality for all is something that can never be underlooked, and something that many people felt emotionally with her passing is honored now more so than ever.
Well, it sounds to me like these are areas, as I'm thinking about what you're saying, that were really impacted by lawyers, by individuals bringing cases, and by judicial decisions because sex discrimination was outlawed going back to 1964, and that law has developed dramatically in the ensuing years. I want to turn to you, Scott, to talk about minimum wage laws, because I know this is an area where individual workers have made an enormous contribution to workers' well-being.
Well, that's right. A lot of people watching this are going to remember when the minimum wage was $8 an hour, which it was for more than half a decade. It was stagnant even as the economy was growing. And eventually in 2014, it began creeping upward. But a lot of people don't remember why. And a big part of the reason was the fight for 15. Fast food workers who were working for minimum wage were in some cases going on strike, but in any event being very active in the fight for $15 an hour. It was perceived at first to be an outrageously large sum, but if you looked at it on inflation adjusted dollars, these workers were actually at $15 an hour. They were not matching what they made back in the 1960s as a result of inflation. So the fight for 15 worked in a number of states. In California, the minimum wage is now $14 an hour. It'll be $15 next year for the large majority of employees. Employees of very small companies, it'll be an extra year before it hits $15 an hour. But why did that happen? Because it was the right thing to do? No, it was because, well, it didn't happen because it was the right thing to do. It happened because people made noise. And eventually the legislature, the people in the position to change the minimum wage realized that they were right. So it really was the right thing to do, but it wasn't going to happen without that citizen involvement. There's not a chance.
Very briefly, businesses complain that raising the minimum wage hurts businesses, hurts consumers, prices will rise. They see it as a zero-sum game. They want to be the winners, and low-wage workers are supposed to be the losers. Give me one good reason why that's not true.
Well, yeah, it's just nonsense. The unstated underlying assumption is that when you give the workers these wages, the money goes into their pockets, never to be seen again. And it's ridiculous. The money that goes to an American worker is spent before, certainly by the next payday. Economists call it marginal propensity to consume, but it's essentially 100%, or so close that the difference doesn't matter. And what do they do with their money? They give it to businesses because they're buying stuff. They're buying services and goods. So the money goes right back into the economy immediately. And ultimately, that's what drives the economy. So the businesses aren't going to be bankrupted by paying $15 an hour. And we've seen they're paying $14 an hour and business is booming. So the representations that you've described in opposition to raising the minimum wage were just plain false.
Well, 70% of our GDP of our economy is consumer driven. So putting more money back into the economy through low-wage workers is a great way to stimulate the economy.
It absolutely is.
So our third example we're going to use here is one that I'm very much involved with, having to do with religious discrimination laws. The Sikh community, along with the Muslims, were demonstrating years ago, and one of our assembly members who was present asked what could she do to help, and the answer was workplace religious freedom. Well, Assemblymember Yamada introduced that bill in 2012, and I quickly introduced myself and worked in shaping the language and working with the coalition to get it enacted. It was enacted in 2012, giving California the strongest protections for people of faith in the workplace of any state in the nation. And before we're done with the webinar, towards the end, I'm going to give you a little more detail on that and on just how individuals can obtain Sabbath accommodations or religious accommodations for their employment needs. Before we finish out this segment, Any final observations, Beth or Scott, on this, on just how much individuals can do to make a difference?
Yeah, there's a wonderful interview in 2019 of Dr. Blasey Ford. And she says that she was inspired by Professor Anita Hill and her bravery and testimony in 1991. And because of her inspiration, Dr. Ford felt courage to come forward 27 years later. And interestingly enough, there was an interview a year after Dr. Ford's testimony where Professor Hill similarly says she felt brave and inspired by Dr. Ford to come forward and speak about her experiences back in 1991. When you speak to many young women, ladies, girls, and attorneys across the country, they tell you about their inspiration is these women. When they talk about coming forward, about being activists. And what's interesting is what you said earlier, these are all individuals, and it shows you the power of individuals to affect change. It's not just one case, it's one person. Each one of these people have made such a significant difference. It's a wave, it's the butterfly effect, and it's actually quite powerful.
Well, and I would just, since we're talking some about sexual harassment, point out how important it is for women in the workplace to speak out, because otherwise harassers are emboldened to keep mistreating others. There's no editing of these recordings, but that was my little timer going off. I have a few more seconds. So I just want to say, especially undocumented workers need to speak up, because they are especially targeted in the workplace. And it's, especially because they are perceived as vulnerable and that they won't speak out. And unless they do, the harassers are going to do far more damage. Okay, well, I guess we're back now live. Beth, I think you're going to join me here. I don't see any actual comments or questions from folks. I wonder if you have any thoughts looking at that. That was our first time trying this recording, and we love StreamYard. It does a lot of nice things for us, but we got to get used to it.
Yeah, I did have one follow-up comment about undocumented workers. And it is a real dilemma for undocumented workers. There is a systemic fear that they have from speaking up after being victims in the workplace. There is great evidence that they are one of the first to be targeted in the workplace because they're the easiest to threaten. They'll call ICE, they'll call the government, so they're most likely to be quiet. And we have come off of many years where that fear is very real. So the stories we hear in legal aid and in plaintiff employment offices from the few that have the courage to come forward is really horrifying. So we really thank the employers for treating them well and encourage those to come forward who have the strength to come forward, but recognize the fear is very real. And it's going to take some time to say that you're welcome to be here, you're safe, we hear you, and please don't be scared. We don't want you to suffer. And that's going to take a lot of time to unwind.
The fear is so real. We have been sponsoring immigrant rights programs in our churches over many years. And so if you have any, if anyone from any of our Spanish churches in particular or immigrant churches are listening, feel free to call on us. We've got some good immigration lawyers. We've often invited folks from our civil rights agencies, our state and federal agencies to join us. But the last one, and we often will get a very strong turnout, hundreds of people, but the last time we did one at a very large church, we had 25 people in attendance. And the pastors were saying people are afraid to show up at a church. And I want you to know, too, that it is official policy, hands off the churches when it comes to immigration enforcement. Doesn't mean that it's illegal for them, for the authorities to come, but the official policy is hands off, and that has been honored. Well, any other thoughts before we go to segment 2? Let's go ahead and see how our second recording turned out. Welcome back. Now in this segment, we're going to be talking about the big ticket issues that are facing workers today. At least have time to identify a couple of them. I think, Beth, we're going to start with you, and we're talking about mandated vaccines. There's a lot of people who have chosen not to get vaccines and are very concerned. And obviously, there's some of those decisions are medically based and some are religiously based. A lot of concerns about the possibility of increased vaccine mandates. Where do we stand with those?
Yeah, that's a fabulous question. The law and the guidance on that constantly felt like it was changing, but I feel like today, as we sit here and we're chatting, we have a little bit more solidification. Employees can look to the federal government EEOC website, and we'll put the link up for you, or the state of California Fair Employment and Housing website, and we'll put the link up for you. They have really wonderful Q&As, easy posters for employers, and a lot of data available. Right now, an employer may require an employee to take the FDA-approved vaccination against COVID infection as long as the employer does not discriminate against or harass an employee or job applicant based on protected classifications. What does that mean? If someone has a protected classification and says, I'm not taking that vaccination because of my disability, something where it's certified due to a doctor, or because of a sincerely held religious belief, and they therefore are not taking the vaccination. If they are discriminated against or harassed because of those reasons, then they may have a reason they need to talk to an attorney. I know one sitting right here that may be able to talk to them about the religious beliefs. And so we're going to put those links in there for you. You're definitely want to walk through it. It's complex and confusing, and it can feel really scary with a lot that's been going on right now. But yes, employers can ask you to be vaccinated other than those carve-outs. And also on face coverings, just real briefly, those rules were just updated. If you're fully vaccinated, you no longer have to wear a mask. But if you are not, an employer can require that you be masked in the workplace.
And there's a lot of confusion. I know people think, well, how come the employer even gets to ask me, don't I have privacy rights? And they will invoke HIPAA. But why don't you explain how that works?
I think that's a great question. And I think there's a difference between HIPAA, I am not fully vaccinated, or I have a disability and therefore I don't want to be vaccinated. You don't have to answer those questions. When there is a pandemic, there's different rules that apply and rules that get relaxed. And we have been in that status since about March of 2020. So you don't have to explain or disclose any of your confidential medical information. You just have to answer yes or no. Are you vaccinated? If you want accommodation that rises to that next level, therefore you are worried about privacy issues with your medical issues and your disabilities, yes, you need to be worried about HIPAA and privacy. But then you go to those EEOC websites or the DFEH website we're going to give you, and how to carefully navigate that to protect your privacy. But for the most part, you should not be disclosing your private information, and the limited private information you have to give your employer, the employer has to protect. You are important, and they have to protect that information.
I know we're going to have a much longer discussion of this issue next week in a webinar that the North American Division is going to be producing. So keep your eyes open for that. Scott, we're going to go to you next. Forced arbitration is something that you've been working on against for a long time. Our legislative committee has been tearing our hair out. I still have some of mine, but we've been trying to figure ways around this for as long as Beth and I. Beth's been with this committee for 10 years, and I think I've been at least that long. What is forced arbitration? Why is it such a problem for American workers?
Well, okay, let's start at the start. Most people, I think it's clear to people that if they're at a red light, stopped, and somebody rear ends them, they can take the person to court if the person doesn't pay all of the damages voluntarily. It's a pretty clear-cut case, and there's no relationship between the person who was hit and the person who rear-ended. Whenever there is a contractual relationship, there is a danger that, as is the case in an employment relationship, there's a danger that the employer, the stronger party in the relationship, will have put an arbitration provision in the employment agreement. And it's called forced arbitration because the reality is if you want the job, you're going to sign the employment agreement. And what it means is if you get into any kind of dispute with your employer, whether it's about discrimination, about wage theft, about anything else, you are obligated. You don't have a right to go to court. If you try to go to court, you'll be shuttled off into arbitration. The employer will be able to force you to arbitrate the claim. Who are the arbitrators? Some of them are retired judges. A lot of them are attorneys. They don't even have to be that. But they're people who charge a lot of money to sit in judgment in judgment of secret proceedings. These are not public proceedings, and decide cases. And they know who the repeat players in the system are. The repeat players are the large employers or large, you name the type of company. It could be an auto manufacturer. It could be any. These happen in consumer relationships. But it's whoever is drafting the arbitration clause and picking the arbitration forum and selecting the arbitrator off of the list. The arbitrators know that if they want to make $900 an hour or $500 or whatever they happen to be charging, and those are typical kinds of numbers, that they're not going to irritate the party that is in the stronger position and is putting their name in that agreement. And this is the biggest problem most people don't know they have.
The companies are paying for the arbitrators. They're requiring you to go to arbitration, and the arbitrators know that if they want to keep getting work, they got to be.
That's generally the case. It actually gets more extreme than that in some contexts. Like, for example, in securities arbitration, the customer who lost her life savings because of the inappropriate conduct of the broker has to pay half of the arbitration fees.
Ouch. Well, we need to go on to our next issue. And Beth, we've got about 2 more minutes to talk about what you're seeing in legal aid with the problems faced by low-wage workers, wage theft, etc.
Yes. So I've been volunteering with Legal Aid at Work with low-income worker clinics that they have throughout the state. There's 15 right now, and the need keeps growing. With a low economy, with a bad economy in times like this, we see a dramatic increase of wage theft claims, money missing from paychecks, overtime missing from paychecks, paychecks that never come, paychecks that bounce. We see a great increase in the victimization of certain populations. We see victimization increases against undocumented workers, single mothers, single parents, disabled persons, and that it comes of anything of someone with breast cancer, someone who's pregnant, disabled could be anyone from the mentally disabled person. So the great increase in that area. And then we see an increase of lack of access to the court system, with the courts being closed, but also just a lack of access for low-income people. They don't have the money to pay for an attorney. They don't necessarily have the means to take time off work, to hire an attorney, to miss a day of work, to just have the time and comfort to research and put the time and effort into it. It is hard. So we're seeing a dramatic increase in that need, which, if resolved, would help everyone. So we're going to put a link in there of Legal Aid at Work. They do a lot of great work with free fact sheets, how to do it yourself sheets, handbooks, and the 15 free legal aid services clinics open to all low-income persons and unemployed persons throughout the state.
Okay, well, let's bring Beth back live with me. You know, one of the things that occurs to me, Beth, when I first started handling the Sabbath accommodation cases, I really wasn't paying attention to the kinds of wage and hour issues that might be there. But increasingly, what I find is it's really important to be asking folks, well, what about overtime? And looking at their pay stubs, were they paid properly? And we often find that people are not being paid properly. It's just an epidemic. And as much as employers, and especially the large ones, they have good law firms that are cracking the whip, telling them what they have to do. And they know what they have to do. And it's just surprising how often they just don't get it right, isn't it?
Yeah, there's multiple types of things that we see, from even the large employer to the small family employer that tries to do the best. And often minimum wage is misunderstood. Lots of local locales have their own minimum wage. It can be different from Oakland and the size of the employer to Los Angeles to the size of the employer. You really should pay very close attention to where you are, because state minimum wage is very different from city and county. And then on top of that, we see things like you're using your phone or your car for work. And did that rise to the level of, should you be reimbursed for that? And so we see reimbursement violations. And you know, when you get your paycheck, you want to see what happened. Pay stub violations happen a good deal. Sometimes people never see what happened to their paycheck, how it was derived. There's all sorts of kind of the everyday not getting paid for don and doffing uniforms, the time it takes to do the kind of the simple things. People show up, waiters and waitresses and support staff, they show up, they do the get ready stuff. Maybe they're not getting paid for that. But sometimes that's work and it needs to be looked at. So there's many layers of things.
Well, and you know, I'm thinking too about the first topic you talked about in that segment, the mandated vaccines issue. And I mean, there's some who think that we're going to face a lot more of these mandates. But the big story that came in the news this past week, I think it was a week ago, was a decision out of Texas involving Houston Methodist Hospital. Now, the news has been picking up on the story because there were 150 some workers there that did not have an accommodation request. They simply did not wish to vaccinate, and they sued and they lost. And the hospital won the right to require that mandate. And surely in a hospital setting, in a healthcare setting, the concerns of the impact on third parties, on patients and staff, and keeping everybody healthy, that's going to be as significant as about any other workplace you're going to find. But the part of the story that hasn't gotten the attention, there were more than 300 workers who were granted medical and religious accommodations. And I'm still trying to find out how they were accommodated, because in a lot of workplaces, now, don't get me wrong, we encourage people to get vaccinated. We want people vaccinated. We think it's important. The Adventist Church encourages it. But we also recognize that there are legitimate reasons why some people can't be vaccinated. And, some with religious accommodation requests are also valid and need to be respected. And I think in a lot of places, there are safety measures that can be taken, but we just don't have the full story really at this point on what accommodations are being done. So I want to urge our listeners, if you or anyone if you're aware of how employers are accommodating, let us know. This is something we need to keep on top of, whether it's a medical or a religious accommodation. Any other thoughts on that segment? The only comment was annoyance with our failure to turn off our notifications there. We'll try to get it right the next time. That was in the pre-recording session. Okay, Daniel, you're asking about the 150 holdouts that were stubborn. Well, but they didn't have a legal, what the court decided, they didn't have a legal right to refuse the vaccination. The employer had the right to require it. Okay, I think with that we go to our third and final recorded segment. And we're going to, so in this last recorded segment, we're going to be talking about what a difference we've made with recent legislation, the differences that people have made, and a couple of measures that are still in the hopper that we're trying to get passed. So Scott, I think we're going to start with you, and we're going to talk about Senate Bill 1300 and what came out of the Me Too movement.
So the facts behind this one are shocking. This did come out of the Me Too movement, and our organization and many others pushed for the enactment of Senate Bill 1300, California Senate Bill 1300. California has long had strong protections against discrimination and harassment in the workplace, but too often judges wanted to throw cases out before they got to a jury. Well, there's an old saying that sometimes you have to break down to break through. Well, this was the breakdown event, this particular case. It was a supervisor, a 911 supervisor, who was fondling and groping a 911 operator for the entire duration of an emergency call. The supervisor was convicted of criminal assault. Yet when the operator sued for sexual harassment, the court found that it wasn't sufficiently severe or pervasive to get to a jury. So the court took it upon itself to throw the case out. Well, that was the last straw. And Senate Bill 1300 fixed that problem by making it much harder for judges to throw cases out and effectively to require the cases to get in front of a jury where they belong.
So this is really about protecting people, right? I mean,
well, yes.
This is the one free grope case. It's
yeah.
not acceptable to, say that, oh, it's okay to do a certain amount of unwanted touching.
Well, that's exactly right. And they're not just protecting the people who've been groped. You're protecting all the people who aren't groped, because the law now is stricter, and employers are making sure to prevent these kinds of things from happening in the first place. Ultimately, law is about creating incentives, and ideally you want people not to do the crime. Rather, you're not trying to put people in jail. You want them not to do the crime.
Right. Well, and I think that's an important point, Scott, because a lot of times we think, oh, well, this is just giving people the right to sue, and it's, good for lawyers. What we're really trying to do is keep people out of court and prevent bad things from happening.
That's the whole purpose of it. So you can even look at the 10 Commandments, and that's how they're phrased. Thou shalt not.
Okay. Well, Beth, the COVID, the whole pandemic has been an enormous challenge for workers, right? Especially, frontline workers. And there was a lot of activity right from the get-go. Now, what do we do? How is this going to impact? How did lawyers and rights groups and all make a difference with all of that?
That's a very good question. It was a tough time for employees. It was a tough time for employers. And from the inception, the government, workers' rights groups, they jumped in and tried to see what they could do. And what was really quite amazing is that everyone was rather fluid with it, because in 1 month, one thing was working, and 1 month it wasn't, and we had to adjust. It was really impressive that we were seeing action from the governor's office and the legislature. Some was by executive order, so because that's all that we could do. And so first we would see that unemployment benefits and things such as medical leave, paid sick leave, and things such as workers' comp in relationship to COVID were handled by executive order and dealt with by this workers' rights group, working closely with the governor's office. And then over time, as we had time to work closely together, it was put into legislation. And now we see that legislation is, we're able to see how that's developed into society now addressing changes and how COVID has had us looking at how life has changed. And so I don't know if you want me to talk about some of those changes we now see in new legislation as well.
Well, if you want to pick one out, go for it.
Okay, so one of the ones that California Employment Lawyers Association has worked on with our work and family partners is AB 1041 or 1051, and it is a current legislation that is designed to expand the definition of family. What we found in COVID is not everyone had a caregiver that was a sister or a parent that helps them through this illness. It was the best friend from church or the neighbor across the street, and that the law was not designed to protect that friend from church or the neighbor across the street if they took time off to care for them. And that neighbor or that friend from church could have been fired or not accommodated. And so we were really excited to work with our friends and partners in the work family coalitions and say to the government, those people need to be protected. When they are at home taking care of someone who's sick from COVID or the side effects of COVID, because we have some long haul people that are still really suffering, that they should be able to designate that person as their designated caregiver. The great side effect of that too is it takes a lot of burden off the employers of not constantly having to redesignate people and struggling to figure out who the designated caregiver is. So it actually streamlines the process, makes it less difficult for the employer, clearer for the employer, reduces paperwork, and actually helps employees designate a caregiver and broadens the scope of family.
And this one's still in the works. It hasn't passed entirely. Passed what? The assembly first?
It's actually flying through pretty good. It's almost through the full process in the legislature, but it's not yet at the governor's desk for signature. The coalition to supporting this has been broad, extremely broad, because it is multi-generational families, and employers so far have been pretty supportive as well. So it's been smooth for so far and unique.
Let me go back to Scott, and I will say that Church State Council has also been supporting that measure. It's very much a pro-family measure and pro-workers' rights. In connection with what our earlier discussion of arbitration, the whole notion of burying cases, burying things privately, confidentiality agreements, non-disclosure. This has been a big subject lately, and I know there's a bill, Senate Bill 331, Scott, that takes non-disclosure to new. Go ahead.
Okay, so Senate Bill 331 is currently pending before the legislature. It's one thing to give people rights, but it doesn't have as much effect as you want it to if they don't know their rights. And as a result, Senate Bill 331 would tighten employee protections from workplace illegality and from forced secrecy provisions. And it would go beyond what Senate Bill 1300 did. So in either an agreement in exchange for a raise or a bonus, or as a condition of employment or continued employment, or in any agreement related to an employee's separation from employment. In all of those categories, SB 331 would require inclusion of the following language. Nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you have reason to believe is unlawful. Note that the agreement that violates that section is against public policy and unenforceable. So the employers have to tell the employees their rights. And it's not just for protecting the employees, it's for protecting the public. Ultimately,
looks like we got cut off on that one. But ultimately, the point of having these NDAs, and let's bring Beth back into the discussion, the point of of not burying people's rights claims in secret, letting companies pretend that it didn't happen and just pay people off. You've been working a lot on these issues.
Yeah, it's a really the silence no more is what we call it in short. You know, and it started initially after Me Too. One of the bigger complaints that came out of Me Too was, you know, this is all happening and no one knows, because these cases are resolving or not resolving because it's kept in secret. It's in these silent situations. And the whole goal is silence no more, is that we cannot affect change. We cannot help put an end to these problems when people are kept silent. And so we're trying to bring an end to that silence. And not only as like a mother, I want to help my daughter have a better place. I want her world to be safer. I want it to be better. And if I'm forced into silence, I'm not helping make it a better place. And so we're trying to stop that for everyone, not just on sexual harassment, but race, gender, national origin. We're trying to make it a better space for everyone who comes behind us.
You know, I'm seeing a little bit of a pattern here. I want our listeners to appreciate the unpaid volunteer efforts of lawyers like Beth and Scott and so many others who are working to advance your rights. And, you know, not all of these bills are somehow full employment bills for lawyers, the way the Chamber of Commerce and some of our business opponents like to pitch them. But you know, bring Beth back, because what I'm going to say now about the NDA situation is there was a long discussion over a course of many years about the NDAs and how, as lawyers, it makes it easier for us to settle cases. You know, and lawyers who are working on a contingency fee have benefited from being able to get cases resolved because companies are willing to pay and keep everything confidential. And so, you know, to some extent, working on silence no more may impact the bottom line for some employment lawyers. You don't think so?
No, and I think that is a misunderstanding, but an understandable misunderstanding, because it has been this structure for so long. But the lack of confidentiality, the disclosure agreements have been in place for sexual harassment cases for a while now, and we as employment attorneys have seen absolutely no change in those cases, in the sense that if they're going to resolve, they're going to resolve. If the value of the case is the value of the case, it is what it is.
Good.
What it doesn't, the behavior itself needs to stop.
Right.
And
I agree.
if anything, the fact that there's a no gag order, so to speak, on the behavior that's preventative. That's about it. That's the only somewhat change we're seeing.
Well, I know there was only one other bill we talked about wanting to bring up here, and that's a bill that Church State Council has been working on forever. It, you know, predates Natalie, our assistant there in Sacramento, has been with us since 2012. And when I asked her to pull up our support letter, she couldn't find it because it predated her. So it went back at least to 2011. So we've been working on this at least for a decade, and that has to do with leave for when close family members die, otherwise known as bereavement leave. Why don't you give us a little briefing on that, Beth?
Yeah, so AB 95 by Assemblymember Lowe is a bereavement leave bill that California Employment Lawyers Association has tried for many years to get passed. And one would think after COVID that we would have had a better chance. But unfortunately, after significant efforts with our partners, it didn't make it this year either. And I wanted to flag it for you because I think it's so important and want to flag it. So hopefully next year when we give it a try again, we have support from other partners as well, because having this time for personal family reasons and religious reasons to be able to mourn the passing of our loved ones without fear of retaliation or termination would be absolutely invaluable. And so unfortunately, it's just one of those things that after several years of trying, it still has not been able to get through.
And I don't see any reason. It just doesn't make any sense to me. So boss to worker. I'm sorry your dad just died, but if you don't come to work tomorrow, I'm going to fire you. I mean, what does that say about our whole attitude about the workplace? It's just, it needs to be reconsidered, doesn't it?
Yeah.
Especially in a nation that wants to, at least some want to call this a Christian nation. That doesn't seem very Christian to me somehow. Okay. Beth, when you agreed to join us here, I know you've done a lot of work, and I attended one of the webinars that you arranged on anti-Semitism. And I wanted to ask you to, we're going to switch gears here. I wanted to ask you to take some time and share with our Christian audience, what you would like them to know about anti-Semitism. I know it's been, with the recent violence in Gaza and Israel, there's been a rise in anti-Semitism. We've seen with the emphasis on the branding the pandemic as having Chinese origins. There's been a rise in anti-Asian violence. And so talk to us for a little bit about some of these issues.
Okay. Well, I appreciate the opportunity to talk to you about this important issue. I'm only going to be able to talk about a little bit of it, but it is still important to have this space to do that. So I was raised with the concept of tikkun olam. I don't know if anyone's heard of it before, but it means repair or world repair or repairing the world. And the roots of it come from the concept of in the interest of public policy. The modern Jewish circles, it really has become synonymous with human responsibility for fixing what is wrong with the world. It's a mitzvah or a good deed to engage in social action, pursuit of social justice, pursuit of social action, charitable acts of giving, or acts of kindness. Because of that, something I've been raised with since I was very young, something that's ingrained in who I am, I do approximately 25%, at least 25% of my everyday work is pro bono, volunteer work. And then I give a good portion of my income to organizations who do the same. I find that many of those people who I were raised with have similar values. And the great words of Representative John Lewis mean so much to me. When you see something that is not right, not fair, not just, you have a moral obligation to do something, to say something, and not be quiet. Those words mean something to me. They mean so much about what tikkun olam is. So you see a lot of Jewish attorneys in the civil rights space. So I wanted to give you that understanding because there's a lot of joking sometimes about why do you see so many Jews in civil rights spaces, and that is a lot of where it comes from. So anti-Semitism, what does that word mean? It's used a lot. It does actually have a definition. People often just think of it as the hatred of Jews just because they're Jews. That's actually a basic, good definition. But there is a formal definition that came about in 2016 in the International Holocaust Remembrance Alliance, which was formally adopted a definition. The United States is part of this alliance. The definition is anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews. Rhetorical and physical manifestations of anti-Semitism are directed towards Jews or non-Jewish individuals and or their property towards Jewish communities, institutions, and religious facilities. That's a long definition. I think most people just go towards the hatred of Jews because they're Jews. Recent rise in anti-Semitism, which really was in the last several years, is often tagged for many reasons, including some which we'll describe in more detail. The failure to understand the difference between disagreeing with the politics of a country, the country of Israel, and Jewish people or their religious beliefs, so tagging the two together. The lack of confidence in democracy, increased emphasis on race and national origin identity, a fading legacy and understanding or identity of the Holocaust, a lack of understanding about what anti-Semitism truly is and what it looks like, and increased use of internet and social media, including the increased use of the internet and social media of a place to get your news. And those are increased reasons why we see a spike in anti-Semitism in the last couple years. More importantly, as Alan, our host, noted, we have seen a great spike in the last month, truly, during the military conflict in May. In the May 2021 timeframe due to the military conflict in Israel, compared to May 2020, there was a significant spike in anti-Semitism in the United States. The ADL, the Anti-Defamation League, says in their tracking that it was a doubling between the two May 2021 and May 2020. During a 2-week of military conflict between Israel and Hamas in May 2021, there was a 75% increase of anti-Semitism incidences reported in the United States. Those incidences were 251 incidences compared to 115 in the same 2-week period last year. In that 251 incidences in the United States, 11 of them were violent assaults. In that period, ADL tracked over 17,000 tweets that said Hitler was right. I have to pause. A group of protests occurred that one included a protest outside of the Temple Beth Israel Synagogue in Skokie, Illinois, that name might mean something to you. They were taxed at that synagogue years prior, where many were murdered, including a pro-Palestinian protest that said, "From the river to the sea, Palestinian will be free," and other anti-Semitic comments. There is dozens and dozens of examples of things that happened in that time frame. Many of these incidences appear to have been perpetrated by individuals who scapegoat American Jews for the acts of the Israeli government. Again, that's what we're talking about, the inability to separate the two. This can be a difficult element as many American Jews hold a connection to Israel as an important part of their religious, social, or cultural identity. Even so, Jews are not responsible for the conduct of the politics of a government of a country. So that's an important concept for people to understand. I am Jewish, but I am not responsible for the conduct of the politics of a country. And those are very hard things for people to separate. Hate against Jews, though, in the May timeframe in 2021 is not new. There was 2,100 cases of assault, vandalism, and harassment reported in 2019 in the United States. There was the third highest reporting of assaults and harassment in 2000 of anti-Semitic incidences since they were first tracked in 1979. So we have had a growing rise of anti-Semitism in the last 3-4 years. This anti-Semitism has been present. It is something that we live with. That is true. American Jews do, but we also live with the concept of tikkun olam. And so at the same time, we understand that despite that, we fight discrimination not just against ourselves, but everyone else. Because when we help fight discrimination, it makes it better for all. I recognize that when I take my daughter to school at a private Jewish school, I drop her off, but I also had to pick her up when a gentleman came to her school and threatened to shoot it up. There is heightened security at her school. Her school has bomb shelter. It has bullet glass. And she knows that. I have lived that life, but we still fight discrimination together because she knows and I know that the world is a safer space for all of us when we do that. Today, my daughter is at a summer camp that I will not tell anyone where the location is because of the safety of her concerns. There are guards outside her camp because of safety concerns. And when she comes home, we'll go to a protest together because that is what we do. Alan, did you want to say something?
moving. You know, I mean, I grew up as a Jew in New York City, and we were oblivious. You know, I grew up going to private schools with other Jewish kids, and we didn't live in fear. We didn't know anything really about anti-Semitism. So, you know, to hear about how your daughter has to grow up here in, you know, a similar urban environment, we think that we're going in the right direction in America with, you know, equality and respect and, you know, making progress. But in some ways, we're not, clearly.
Fascinating, and I don't disagree with you, but I disagree with you, because though that was a scary day, she went back to school the next day, and she went to a protest with me on the weekend that wasn't about anti-Semitism, because she had to learn the importance of fighting for everyone's rights. We are making progress. That was just a step back, but we will never stop.
Well, and I think our message for our listeners today is, you know, you've got to be part of the solution, right? And your voice really does count. I think it's a common part of the American myth. Oh, my vote doesn't count. So why is all this fuss about voting rights? Doesn't really matter. You know, and you know, my voice doesn't count. The legislators don't care what I think. They're going to do what they're going to do. Well, no, we do get to shape things. Our voice really does matter. So, you know, regardless of what it is that you care about, speak up, do something about it. Did you want to present more of your material before we go into my next segment?
I do think that there is one fact that's important for everyone to know, is that there's a significant misunderstanding about the Jewish population. Often Jews are perceived as white. I mean, it's hard for me to say it because I'm the whitest looking person in the world. But the Mizrahi Jewish population is black or brown for the most part. They come from Middle Eastern areas or Northern Africa areas. And for people who haven't been to Israel, maybe they don't know, but Israel is actually about 50% black or brown. So there is a significant misunderstanding that the Jewish population all looks like me. They don't. And that does create some interesting issues in the Jewish population, because the left often looks at them as white, and the right, or like the alt-right, for example, you know, looks at them as non-white when they have their issues with them, without getting too political. So it is a big misunderstanding about the Jewish population. And to your point, Alan, that's really important, is everyone has a voice. And that's something I do really appreciate about the ADL, the Southern Poverty Law Center, and other organizations that have started recently with AAPI Hate or Anti-Hate. They created these wonderful tracking organizations and websites where they encourage people to report what they see. Because when you report, they can make a difference. They can track, it encourages other people to report and speak up and say something. So ADL not only takes action on behalf of Jewish people, but all people who have suffered hate and discrimination and violence. So they encourage reporting and tracking. The Department of Labor and Employment Housing has a violence reporting. The AAPI has an Asian hate line for reporting, which has unfortunately been very necessary since March 2020 due to some massive increases in hate crimes against the AAPI community. So these types of things are really important, is that people are reporting what they're seeing, the holler back, the standing up for those around you. It's invaluable.
Well, there is one more misconception that I'd like to address before we leave this topic. My first job out of law school, I worked in a legal services office in Brooklyn, New York, and it was an office that was set up for, get ready, the Jewish poor. Now, if that is, in most people's minds, it's an oxymoron, right? Because we have these stereotypes of Jews and money, and it's a stereotype. And we don't realize that in our big cities, the Jewish poor is a reality. And I'm just, my mind's wandering back to the whole process of immigration and how, the Jews who were here first and had gotten themselves economically established, they set up charities long before we had welfare and public benefits. We had the charities that would help the newly arrived immigrants, help them find a place to live, help them find work, etc. And we've always had a wide variety of economic success and lack thereof. But of course, in the popular imagination, and Jews tell jokes on themselves. I just heard one recently from Scott Bernstein's favorite, Kinky Friedman. But anyway, we'll leave that alone for offline. Well, the other thing, that I really appreciate about what you were talking about, Beth, is the commitment of the Jewish organizations to working for the rights of everybody. And that's something that we certainly share as Seventh-day Adventists in our work for religious liberty. I was mentored when I first came here that we don't just represent our own church members, we'll represent anybody that comes to us needing help. And as we've developed over the years a good reputation for representing persons of faith, we've had many more opportunities to help people of all faiths, Jewish, Catholic, Mormon, pretty much any across the board. So I'm going to move into my last segment here, which is going to be about Sabbath accommodation. And so we're going to take just a few minutes to brief you on what do you do when the all too common problem arises about getting Sabbath off from work. And I'm going to start with the job application, because we worked for many, many years to get a regulation in place that requires the employer to put a kind of a disclaimer in the application, because it's common for companies to ask, when are you available for work? And they'll have charts showing the different shifts, 7 days a week. Maybe there's 3 shifts a day. Maybe there's 2 shifts a day. And you've got to check when you're available, right? Well, now the regulation that was passed and came into force July 1 of last year requires companies to notify job applicants not to disclose their unavailability if it's because of religion, medical condition, or disability. So when you apply for a job, know that your need for accommodation is not a factor in whether you get hired. Now, after you get the job, I certainly would encourage you at the first opportunity. Hopefully you've built at least some kind of basic personal rapport with the person who's doing the scheduling. And by all means, let them know, hey, I'm an Adventist and, I need a schedule Monday through Friday, or, I can work 6 days, I can work holidays, I can work any day, but I can't work on Sabbath. And in terms of protecting your rights, the one thing that you have to do is put it in writing. If it's not in writing, it didn't happen. When by the time everything blows up and you're talking to me about legal representation, I guarantee you, if you didn't put it in writing, it didn't happen according to the company. You can ask them if they have an accommodation form you can fill out, or we have a bunch of letters on our website. You can go and submit letters and be gracious, but make it clear it's because it's your religion. Has to be clear that it's a religious thing. So what is your rights? And I'm going to just take a moment to put it very simply. So the law says that the company, the employer, has to provide reasonable accommodation. Well, does everybody have to do it? Well, if there's 5 or more employees here in California, then the answer is yes, under state law. Federal law, it's 15 or more. And in some states, we're subject to that limitation. If you're on an Indian reservation, believe it or not, they're governed by their own sets of laws, and these laws don't apply. So what is reasonable accommodation? Well, reasonable accommodation to the employer might be, I'll meet you halfway. I'll give you a couple of Saturdays off in the month, but you're going to have to work 1 or 2 Saturdays a month. Well, Seventh-day Adventists generally are going to say that really doesn't work for me. The Sabbath is a commandment, and I don't work. God has commanded me to rest. So legally, it's very clear it's not an accommodation unless it eliminates the conflict between the religious duty and the work obligation. And that's another regulation that we got enacted several years ago, the recognition here in California that if the accommodation does not eliminate the conflict, it's not an accommodation. Well, does the employer always have to eliminate the conflict? Do they always have to accommodate? No, there's a balancing test, but the balance is referring back to the Workplace Religious Freedom Act we talked about much earlier in the program that we enacted in 2012. That clarifies that the standard that the employer has to meet to show that an accommodation would be too hard for them, the standard of undue hardship, is a significant difficulty or expense. It's the toughest standard for any type of accommodation in the nation. Significant difficulty or expense. And I can tell you that religious accommodations, by and large, almost never cause significant difficulty or expense. I can think of 2 times in almost 30 years where we have said to someone who was, a potential client, well, under your circumstances, I can see how the employer can't provide the accommodation. I think twice out of hundreds and hundreds of situations, we felt that an employee could not be accommodated. Well, what happens if you request the accommodation and the company says no? Well, you may want to get your pastor to contact them or send a letter, but if they're really saying no, then that's when you need to reach out to us at the Church State Council and let us assist you. If we need to file charges, we go to either the state or the federal civil rights agency, and we start there because you have to go there first. And we contact the company and see if when they're faced with potential legal action, if they may reconsider and behave themselves. But ultimately, if everything really goes south, we have developed a really wonderful network of attorneys, many of them through the California Employment Lawyers Association, who work with us and are willing to take these cases on. And we've had really, really wonderful success. This year, just as an indication, the Pacific Union Conference is having our constituency, and we have new officers and all being elected by the constituents. And those of us in the different ministries have had to submit reports about the last 5 years. And during the last 5 years, we have returned to the Treasury all of the expenses that have been spent on cases that have closed out, that have settled during the last 5 years, whether it's gone to trial or whether it's been a settlement. In other words, we haven't lost any cases during this past 5-year period. The Lord has been good to us. We've had a good success rate working not only with our members, but as we said before, people of many different faiths. So looks like we're a little bit ahead of things on our schedule. We're prepared to go to 5:30 if need be. I'm wondering if there are any questions from the audience, or Beth, why don't you come back and let's see if you have any thoughts for a few minutes, and then we'll have Elder Lee close us back out with prayer. I think are you muted? Is Beth?
Thank you for flagging that.
Okay.
No, I think actually earlier this year when we were discussing anti-Semitism cases, one of the things we noticed is that there hasn't been a lot of people litigating these cases. That you have made more strides in that line of cases than almost anyone else, which is really fascinating because people will speak up about some anti-Semitism, but they're not litigating those cases. And we're not seeing as much movement in that area. And so it's really fascinating to watch what's happening and question why. I don't know why yet, but it maybe there's a pattern, maybe there's more strength and support in your community. I don't know what that is, but it's just something to note.
Well, my observation, Beth, is organizations like ADL or American Jewish Committee that are doing such wonderful work on some of these issues, they're not a legal services organization. And so we have had people who've contacted organizations like that then come to us. And of course, more and more colleagues of ours within the employment law community, when they take in a religion case, I mean, a lot of them are just litigating them, but they also send us cases. So we're getting some that way. And so currently we do have a really bad harassment case against a Jewish individual that I'm co-counseling with one of our colleagues who I think is listening today, but attorney-client privilege and all that. So, I'm very grateful for your participation today. You've been very patient to stick with us through this, and we're learning the process working with StreamYard. It's a lot more fluid, has a lot more functionality than a Zoom meeting does. I hope that makes it more enjoyable for our guests. Apologies for the beeps and things that came through. Before we close today and turn it back over to Elder Lee, I do need to express a really heartfelt thank you to Lori Trujillo, who is our communication director for Northern California Conference of Seventh-day Adventists. And Lori is the one who's been teaching us StreamYard, and she's been our producer today. And so we're very grateful for her volunteer efforts. And whatever's gone well in the production today, we can thank Lori for, and whatever has not gone well, you can blame me for. Elder Lee, I want to thank you again for promoting this event, and by all means, let's keep the conversation going about the issues that our members are interested in and what we can do to better serve our church members and the needs of our churches.
Thank you so much, Alan. I want to thank you for moderating today. I want to thank Beth and for Scott being here with us today. Scott via a pre-recorded session, but still, I think this was a blessing to all that were able to participate and listen in. And we look forward to our third installment come toward the end of August. And so we're grateful again for Alan Ronick, for his leadership in this, for his direction, for his moderation of this particular presentation, and for all the other special guests that were able to be with us and to dedicate their time to us today. We really appreciate it. We hope that you were blessed. We hope that you were informed of many things that relates to workers' rights, and we hope that this has been a blessing to each and every one of you that have been able to tune in to this Sabbath afternoon. So at this time, we're going to have a word of prayer, and we'll close out our presentation for today. Let's bow our heads. Father, we're just grateful for this Sabbath. We're grateful for the opportunity to share. We're grateful for Alan Ronick and his team. We're grateful for our two special guests, to be here today and to share with us their thoughts about workers' rights. We pray your continued blessing upon us as we continue to move forward with much needed information. Now bless us as we can continue our Sabbath hours. Give us a good week this week, and we'll be quick to praise your name, for we ask it in Jesus' name. Amen. We look forward to see you August the 28th for our third installment of our religious liberty presentations. May God bless you, is my prayer.